Good afternoon and welcome. If you'll face me and raise your right hand to be sworn, thank you. Do you swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. If you'll follow the bailiff now to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjustable. Thanks, sir. You may proceed.
Good morning.
Good morning.
Can you please introduce yourself to the jury?
My name is Jacob Becker.
And how are you currently employed?
I am the night shift supervisor with the Pasco County Sheriff's Office.
And what's your current assignment and duties?
As a supervisor in the forensic section, I currently supervise 6 individuals who go out and investigate crime scenes.
And in March of 2017, what was your assignment?
I was a crime scene investigator with the Hillsborough County Sheriff's Office.
And how long were you a crime scene investigator with them?
With Hillsborough for 12 years.
And were you a crime scene investigator prior to Hillsborough?
I was for about 4.5 years with the Manatee County Sheriff's Office.
And what were your duties with the Hillsborough County Sheriff's Office regarding your position as a crime scene investigator?
Our main function was to document the crime scene as we see it and to collect and preserve any potential evidence.
Did you become involved in an investigation with the defendant's name listed as Trevor Summers?
I did.
When did you initially get involved in that investigation?
I was first notified by dispatch on March 12th, 2017, around 7:30 in the afternoon or evening.
And what were you asked to do?
To respond to the residents on Dew Bloom Road and to basically investigate a potential crime scene.
When you arrived there, what did you do?
Took photos, met with Detective Blair, who sort of gave me a walkthrough of the scene and talked about the information as we knew it.
And were you aware of what kind of investigation or crime the Hillsborough County Sheriff's Office was investigating?
Well, we really didn't know the extent of things as we were just getting started. We kind of handled it as a missing persons case at the time.
What did you do as a crime scene investigator at the Dew Bloom residence?
Besides take photos, I marked potential evidence with placards or little numbers so I could go through the house in a systematic order, taking photos, collected that evidence. I also dusted or fingerprinted a few areas of the home for potential latent prints and swabbed a few areas. I also looked for any potential unseen evidence with what's called an alternate light source.
Now, what is your educational background and training in order to hold the position as a crime scene investigator?
I hold 2 bachelor degrees from the University of South Florida, one in anthropology, the other in criminology. I have a certificate in crime scene technology from St. Pete College. Approximately, well, now, probably about 800 hours of various related training. So I've been doing the job for almost 20 years.
Did you, when you go to a scene, are there things that you do upon arrival and a method that you go through and before you actually pick up and collect a possible item of evidence?
Yes, we always photograph it as we see it, completely undisturbed. Then we'll put a marker next to it if we believe it is potential evidence, so we can show where it is in relation to other items of evidence in the scene.
And did you do that in this case?
I did.
May I approach the witness, Judge? Mr. Becker, I'm showing you what's already been introduced into evidence as State's Exhibit Set 1, A1 through 104. Have you previously looked at these photographs prior to responding to the courthouse today?
I have.
And are they fair and accurate photographs of the Dew Bloom residence as you found it on March 12th of 2013?
Yes, it is.
And typically, is there a initial photograph that you take with information regarding the case number, publishing A1, the case number, your name, and the date in which you collect the photos?
Yes, so this is the very first photo that's taken upon arrival at a crime scene. And this just basically shows the case number, the date, and then who's taking the photos.
Did you start on the outside of this residence and work your way to the inside?
I did.
And photographs and documenting?
I did.
And then did you go through the residence, excuse me, and place number markers were items that you ultimately were going to collect?
I did.
When you photograph a scene, do you know whether or not your photograph contains something that holds or has evidentiary value?
Not all the time. Never having been to, like that crime scene in particular, I don't know what it looked like before. I don't know what is potentially evidence and what isn't. So we kind of go off of our training, education, and experience to make the best determination.
And so photographing items were located within a trash can. Did you know whether or not at that time that photograph could contain or did contain something that held evidentiary value?
Knowing what was in the trash can and having been through thousands of houses prior, we kind of found it unusual. We figured it was what we had determined as potential evidence.
So you documented the outside, and then we had just discussed placing markers down, publishing A85. I see a marker too. Is that then what appears to be cigarette butts outside of a window? Do you put a marker, take a photograph of it, and then collect the evidence?
Typically, yes.
Okay. If you lift prints from a scene, and you did lift some prints from this residence, is that correct?
That is correct.
Are you the one in charge of making any kind of fingerprint comparisons?
I'm not. Once I make the lifts, I send them off to our fingerprint unit, who then does the comparison.
And you stated that you also used an alternate light source in this case. What do you mean by that?
So an alternate light source is somewhat of a fancy name just for a black light in this particular case, or an ultraviolet light. So we use this to look for potential bodily fluids, things that aren't readily seen under just our regular vision.
What happens when you utilize this light?
So for some bodily fluids, it will somewhat glow or fluoresce using a black light.
And did you find anything or collect anything after you utilized this alternate light source?
I did. On the master bedroom bed, we found an area that glowed. We deemed it suspicious, so the bed sheet was collected.
Did you respond to any other scenes and document those scenes regarding this investigation?
Yes.
Where was the next place that you responded?
The following day, responded to Tampa General Hospital to photograph the suspect in this case and document his injuries.
And what time was that at?
I believe I was dispatched right before 6 o'clock p.m., and I arrived a little bit after 6 o'clock.
Permission to publish, Judge?
Absolutely.
Mr. Becker, I'm showing you what's been already introduced into evidence. It states Exhibit V, Composite 1 through 10. Did you look at the photographs from TGH prior to today?
I did.
Publishing V1, is this your initial document photograph?
Yes, ma'am.
Publishing V2, is this how you observed the defendant in this case?
It was.
V4. Again, is this a fair and accurate photograph?
Yes, it is.
And he was handcuffed, is that correct?
That is correct.
V6, did you document the self-inflicted injury to his neck?
I did.
And did you also photograph his clothing?
I did.
Did you conduct any interview of the defendant on this date at Tampa General Hospital?
No, I didn't.
What was the next thing that you then did?
I then responded back to my office that holds a garage, and then processed the victim's vehicle. And that was around 7:30 that evening.
And what type of vehicle was that?
A 2009 blue Saturn Outlook.
Now, on this document, did you take a photograph with your name and case number?
I didn't. I was
Okay.
sort of continuing on from, with this investigation.
Okay. States P1. It's a little dark. Are you able to identify whether or not that was the vehicle?
Yeah, that is the vehicle.
Okay. When you document, did you document starting with the outside of the vehicle and then work your way on the inside?
Yes, ma'am.
And were there items that were collected from this vehicle?
Absolutely.
Did you know whether or not the items you collected, whether they all held evidentiary value regarding this investigation or not?
Absolutely not.
Are you involved in any of the interviews in this case?
I am not.
Are you working with detectives who are who have conducted interviews or being relayed information as interviews are being conducted?
That would be correct, yes.
Okay. And if other items of evidentiary value were found upon return to, let's say, the victim's home on a later date that you did not collect, that would have been something that you didn't have information of knowing that held evidentiary value.
That's
Is that
correct. That's
fair to
correct.
say?
Absolutely.
Mr. Becker, I'm going to show you what's already been introduced into evidence as State's Exhibit S1 through 4, as State's Exhibit, as well as Court Composite Exhibit S1 through 4. Did you collect handwritten letters from the victim's vehicle?
I did.
And did you document those letters with photographs first where you found them and then collected them?
Yes, ma'am.
Okay. Were there multiple letters that were located?
3 in total.
Okay. So a surrender of parental rights, publishing S1, was that a document that you had collected?
Yes, ma'am.
Publishing S2, a letter that was titled Confession. Is that a document that you had collected from the victim's vehicle?
Yes, ma'am.
And publishing S3, a dear letter to Arden, Landon, Bryn, Grady, and Cooper. Is this another letter that you had collected?
Yes, it is.
Did you do anything later regarding these letters?
Yes. I tried to develop latent fingerprints from the letters using a chemical called anhydrine.
And what is the purpose of that?
Just to determine who wrote the letters, or at least who was handling that potential evidence.
And are you able to ascertain, did you ascertain any fingerprints utilizing that chemical?
Yes. So I developed ridge detail or potential fingerprints on both sides of all the documents. I then scanned those documents into a computer system, forwarded it on to our fingerprint unit, and they make the determination.
When you apply the chemical to the paper, does that affect the writing?
It does.
Okay, so what do you do in order to preserve what the actual document looks like prior to applying the chemical?
So along with photographs, I also do photocopies.
And so what we just went through in S1 through 3 are those photocopies of the letters that you actually collected and then applied this chemical to.
That's correct.
Publishing S1. And I'm sorry, did you state that you obtained lifts from all three of those letters?
Yes.
Publishing S1, you can barely read out the top, surrender of parental rights. Is this what the document looks like after you apply the chemical?
Yes. Well, this is years after, so the chemicals had a lot of time to work.
Okay.
But yes,
And you were able to lift a print from this document, is that correct?
I was.
Court Exhibit S2. The confession letter, is this also a fair and accurate copy of what the document looked 5.5 years later after applying that chemical?
Yes, ma'am.
And how does this chemical work to assist you in lifting a print?
So we spray or dip the evidence with the chemical, and the chemical, unfortunately, is acetone based. So that's why ink and lead and all those things will eventually be kind of washed off, which is what you're seeing there. But the actual chemical ninhydrin reacts with proteins that are left over from fingerprints, and that develops into ridges and loops and whorls and all that stuff that our fingerprint unit would then determine if it holds any value.
Judge, one of the documents has been edited for trial purposes. Can you please read that?
I will.
And this is for a document, not a recording.
Gentlemen of the jury, I have a brief instruction for you. It is as follows. Member of the jury, you are about to receive evidence. This is a
writing, Judge.
a writing. The court instructs you that the writing has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the writing has been edited should not concern you in any way and must not impact the way you consider this evidence.
Republishing S2. This is the document that you had originally obtained and photographed from the victim's vehicle. Is that correct?
Correct.
And then S2, Court Exhibit S2, that now contains the chemical. We had observed a copy of that. Is that correct?
Correct.
Publishing Court Exhibit S3, the Dear letter to Arden, Landon, Bryn, and Grady. Is this what this document looked like after the application of the chemical?
That's correct.
And are you able to see the areas in which you were able to collect fingerprints on this item easily 5.5 years later?
There's still some ridge detail. It's very faint, but there's still some there.
Judge, can I ask the witness to step down and point to that area that he's referencing?
He absolutely may, and there is a pointer down there. It's a ruler, a yardstick somewhere. Oh, it's behind you that you can use if you need to.
So there's some ridge detail in this area here. And, it's awfully hard to see with the lighting and the reflection here, but it's mostly in this area.
Thank you, Mr. Becker. First witness, Judge. Mr. Becker, I'm showing you what's been pre-marked as State's Exhibit T1 and T2 for identification purposes. Do you recognize these items?
I do.
And how is it that you recognize them?
Those would be the images that I took once the items were processed with ninhydrin. They were then, let me back up a little bit. When anhydrous is applied and you have a result, it's usually a dark purplish type color. So then what I do is I'll put it into Photoshop to enhance the quality of the image, and that one of the steps through Photoshop is to sort of grayscale the item. Basically, you're looking at a black and white image. Kind of eliminates a little bit of the background, makes the item a little bit easier to see.
Are these fair and accurate copies of those latent prints that you were able to obtain from the letters?
Yes, they are.
State offers into evidence State Exhibit T1 and T2.
Any objection?
No objection, Your Honor.
T1 and T2 will be admitted at this time.
Permission to publish, Judge?
You may publish to the jury.
Mr. Becker, we're looking at T1 that is titled Letter Dated 3/13/17. Is that the surrender of parental rights that has the date at the bottom?
I believe so, yes.
Okay. Can you tell us what we are looking at here?
Well, obviously, you see an area of potential ridge detail. Should I get up and point to it again?
If you could point to that.
Okay, so right here is the ridge detail in question.
And you are not the individual who then does any kind of comparison. Is that correct?
That's correct.
Now I'll publish T2 if you want to remain where you're at. And this is titled Letter to Kids. Can you tell me where the lift prints or the latent detail is in this document?
So there's actual several different areas where ridge detail is observed. This area here is probably your best area in order to obtain the identity of the person who touched this item. But you also have detail here and a little bit here.
Thank you, Mr. Becker.
Ms. Johnson, is this a good time for our morning break, or are you almost finished with direct examination?
I am almost finished, Judge.
All right, I'll let you finish, and then we'll take our morning break.
Mr. Becker, did you collect any other items of evidence from the, specifically a swab from the victim's vehicle?
I did.
May I approach the witness, Judge? You may. Mr. Becker, I'm showing you what's already been introduced into evidence at State's Exhibit M. Do you recognize the outside of this document?
I do.
How is it that you recognize it?
It has my initials, my employee identification number, and the date that the item was sealed.
If you can look inside.
Mm-hmm.
And is what is contained within either in the same or substantially the same condition as it was on the date that you collected it?
It is.
Okay. And how is it, what is this?
It's a swab of potential blood.
And from where was this swab collected?
I'd actually have to see the, the evidence again. So that would be from the front driver's seat.
Were there multiple swabs collected in this case?
There were.
Okay. And so you had collected a swab of possible blood from the front driver's seat?
That's correct.
And how do you go about taking this collection of possible blood?
It's fairly simple. You take a sterile cotton swab, a little bit of distilled water, and just wipe up as much of the blood as you, or potential blood as you can. You let it air dry, package it, seal it up, send it to the evidence unit for safekeeping.
And are you in charge of conducting any kind of DNA analysis on that swab?
I'm not.
May I have a moment, Judge?
Mr. Summers, I have a question for you. Please do not think I'm rushing you in any way, because I am not. Just rough estimate, is your cross of this witness going to be very short, medium, long, or no idea?
At least the same amount of time.
All right, then we're going to go ahead and take our morning break. Ladies, gentlemen of the jury, please do not discuss the case amongst yourselves. We're going to take about a 10 or 15 minute break. Do not discuss the case amongst yourselves or with anyone else. Do not do any research related to the case. All rise for the jury. Talked about a short lunch today, but if we're going to do a short lunch today, I have to know now so that I order lunch for them. Do you think, given the state's, I guess, where you're at, that we shouldn't, that we have to?
I anticipate on resting early afternoon, Judge.
With or without? Well, what's your position on a short lunch? Do we need to?
I think that would probably be a good idea. I mean,
Okay. All right, that's fine. So let's make arrangements for lunch. When they come in now, I'm going to tell them we're going to do the same thing as yesterday. I think it's sandwiches from the lunch counter, and that's absolutely fine. I agree. I understand. I want to keep moving. We want to get to the defense side, and the defense has a number of witnesses that we'll discuss at that time.
Your Honor, I have a few things for you. I could ask you now.
Sure.
The clerk asked for a copy of the subpoena for Kimberly Shea, and I wanted to do that on the record. So I wanted to show her on the record, because your other clerk asked that I do this on the record, so that we can arrange the Zoom call for that. And she's only available until 2:30, so that would be my first witness to call if the state finishes up around 1:30.
What says the state?
I mean, I direct examined her. He cross-examined her. I don't know what else that there's left from her testimony at all that was not covered yesterday, that would not be cumulative and already asked and answered, to be honest with the court.
So what's your position? Are you asking me to tell him that he can't call her?
No, Judge, I'd inquire as to what information he plans to get into with her to determine whether or not all of the time spent to set this all up is required, since we are short for time.
What do you intend to go into with this witness?
Your Honor, I just intended to get clarification on the police report and the handwritten statement that she provided to the police.
What specifically? What is not clear?
That she was that her statement corroborates with what is in that handwritten statement.
I honestly don't recall the specifics of the cross-examination. Did she not say that her statement was?
She said that her statement in my cross-examination was that she did see the victim's hand on the window with her.
Oh, okay.
And then on the redirect, the state tried to downplay that as because it wasn't in the statement, and I just wanted to be able to get that more clear on the record that her statement of the victim's hand being seen was accurate.
And I would object to asking you, Judge.
Yeah, I mean, she said that in your cross-examination. So if you call her and you ask her something to say the same thing that she said before, the state is going to object as to asked and answered. I mean, obviously, if you told me something different you wanted to get into, I'm, hesitant to tell you that you can't call witnesses. But if it's something that's going to be asked and answered, I mean, that was the opportunity for cross. And let me tell you this, again, I'm not helping you, I can't help you, I'm not teaching you. But the best opportunity for the defense to get information from state witnesses on cross-examination, because you get to lead them. On direct examination, you can't lead them. So most defense attorneys get all of the information on cross-examination, and that's why we rarely ever see any of the same witnesses being called from the defense. Now, that's not to say that you can't do it. That's not to say that, and that's part of you not knowing, and one of the disadvantages that you are at. But the best place to get that information is when the witness was called by the other side and you get the opportunity to lead them to exactly what you want them to say, which you did some of, but not a lot of, with the witnesses on cross-examination. But that issue, I remember it, and I remember the rehabilitation from the state, and I don't see any reason at this time to have to clarify that. You, in closing arguments, which you're going to have to do since you've discharged your attorney, can argue to the jury anything that the witnesses said. Her testimony, both on direct and cross, is evidence. And on cross, she said exactly what you asked her and what you're saying she said, that her hand was on her head was on her hand on the windowsill. Now, my recollection is that the state got up and then asked, you didn't say that in your report, and wouldn't you agree that your report was written at a time that was more closer in time to what you saw? And that was the rehabilitation. Am I correct?
I didn't ask that specific question, but I asked
Along
her
those lines?
if she had written down descriptions of the male and the female, and was her written statement encompassing of what she observed and thorough. And she had agreed with that. And I said, did you put anywhere in this written statement about the head against the window and resting on the arm?
No,
And
but
she
on
stated
cross, she did say that that's what she saw.
That is correct.
So that's the evidence. So I don't know what you're going to try to do to change. That's the evidence. That's what she said on cross is evidence.
Then I'll strike that witness. I agree with you.
Not a
Thank you.
problem. Thank you.
One last thing, Judge. Mr. Warga, the victim's father, he was under subpoena from the state. I didn't release him, but he would like to come and sit in the courtroom. I'm not planning on calling him, so I'd ask for permission for him to be able to come in the courtroom.
It depends on whether the defense wants to call him. Who is he? Mr. Warga is whose father?
The victim's father.
Victim's father. Do you intend to call him as a witness?
I do not.
All right, then he can come in.
And the other person, Judge, would be Jeff Mathewson. He was only subpoenaed by the state. He was not subpoenaed by the defendant. And I'm not calling him as well, and he's not on the defendant's witness list, so he would like to come in as well.
Any problem with that?
No, I don't intend to call.
Okay, all right, yeah. If they're not gonna, if we're at the point where we know they're not going to be witnesses, then the rule of exclusion doesn't need to be enforced against them.
I just wanted to make sure before they came.
All right, are you ready for cross of this witness?
I am, Your Honor.
All right, let's get.
I'm sorry. There's one other item
Oh,
about
yeah.
the my objection to the state's evidence. There is a hospital interview that they want to introduce with a witness sometime between now and the lunch break, and I have standing objections that I want to know if you want me to do that now or if we want to. When
It
that
might be
witness
better
comes.
to do it now than to send it. If it's something I'm going to have to send the jury out on, I'd rather do it now. I think it's more expedient if we do it now than have to send them out. What's the issue?
Your Honor, I have filed previously. Counsel has filed a motion for suppression in this case, and that is an appellate issue in my with my case. I also object to the introduction of that evidence based on the testimony of Dr. Chesla, who said that I was administered fentanyl. He did not say whether or not other things were administered, but that they were ordered. He could not conclude whether those other things were ordered or if they had any impact on statements that I may have made. Dr. Chesla also stated that he was not directly involved in my care at the hospital, so he couldn't give too much testimony as to that interview that was taken of me. I also object to the condition that I was in due to being Baker active at that time. I believe that that also goes to a variety of rights that I would have had would the detectives had taken that interview or followed procedure in taking that interview. I believe that interview should have not been conducted with the detectives, being that I was under the influence of a variety of administered drugs and Baker acted altogether. I don't believe that I was in any situation or any condition, I should say, mentally or physically, to have given any statement to any law enforcement. I object to the procedure of Miranda that was conducted there.
These are all issues that were raised in suppression before Judge Fuson previously ruled on and are currently before the DCA. Is that correct?
It was actually Judge Kaiser.
Sorry.
And I was working on a false or coerced evaluation for that statement, which was potentially part of something that would have been in this trial, but we did not have the time to do that because I received the orders late from the court.
Well, but those are perfected for the record, and there was something that came up regarding the photo pack that I know that there was a motion that you had filed and Judge Fuson did rule on Friday of last week. And something I was going to say, I don't think that it's necessary. I don't think you've waived it. But a lot of times when they moved it in and I said, is there any objection? You said no. A lot of defense attorneys renew their objection thinking that it's waived. But I believe under the Rule 104 that says that once a definitive ruling on the record is made, party need not renew objection or offer proof to claim error on appeal. So I don't think your failure to object to the photo pack coming in waives any objections or motions that you filed that have been denied. So it sounds like these are the same thing. And obviously, if Judge Kaiser is reversed on appeal regarding evidence that came into this trial, it's going to have an effect on this trial. The state proceeds at their own risk on that. Not at all suggesting that it, I don't know what the risk is, but the state knows that if the appellate court, where you have current issues, reverses Judge Fuson or Judge Kaiser, and I let evidence in pursuant to their ruling that the appellate court says shouldn't have come in because they were wrong, that's going to have a profound effect on your trial if you are convicted and, whether that conviction stands. But I'm not sure, is there some specific thing you objected regarding the doctor's testimony? The doctor's already testified. And it sounds like some of his testimony may be subject to appeal that you have pending. But is there something that the state still has that you're objecting to that has not been ruled on? If it's been ruled on, I'm accepting the rulings of the prior judges.
Not that I'm aware of, Your Honor. I just wanted to get the objection on the record so that when they do introduce it, and I just state that I do object.
And this will serve as an additional step of preserving that. But as I said, I don't think it's necessary, just for whatever it's worth under 104. Once a definitive ruling has been made, which I think it has been, then it's preserved for appeal. You don't have to raise it again. But you have, and that's absolutely fine.
And do you have any issue with me objecting when they ask it, when you ask if it can be introduced?
I don't have, as I said, most defense attorneys will say they renew all prior objections, and I say all prior rulings stand and it will be admitted. A lot of defense attorneys think that they have to renew it. I don't think 104 requires that. But if you want to, entirely up to you.
Thank you, Your Honor.
That's trial strategy, which you're now the captain of your own ship, so you get to make trial strategy. Ms. Johnson, anything else?
Nothing, Judge.
Mr. Summers, anything else?
That's it, Your Honor.
You expecting a witness on Zoom because I got an email that somebody entered my Zoom room? No. Okay, all right. Let's get the jury. Thank you. Anticipate any things that we might have to discuss outside the presence of the jury that we can discuss now?
Judge, the defendant has shown me some of his exhibits. I let him know what I would be objecting to, that he needs to lay the proper foundation to introduce them, such as the cell dump from the Samsung phone, in addition to family photographs that were taken within 2 years prior to the incident. I would be objecting as to relevance. So I don't know if you want to address those now or not.
Let's briefly, what are the photos that were taken? What did you say, 2 years prior?
I asked him. He was not able to tell me the date. He said my victim would be able to tell me, and I informed him that these are his exhibits, and he said they were taken within 2 years prior to March.
Within 2 years of March. What is the relevance? Do you have them?
I do, Your Honor. I believe they're relevant because the victim has attested to the conditions of our family environment, and I believe that these pictures would certainly explain the relevance of our family environment.
So is this, you intend to recall, because you served a subpoena on Miss Mathewson yesterday,
Yes.
and you want to obviously recall her and then introduce those photographs through her, is that correct?
I would.
And the relevance of it is,
To refresh her memory of the condition of our family, of our home, of our life, that she's attested to something different on direct or on the state's case. And
how many pictures are there? Is those in your hand?
Yes, Your Honor. It's about 6 or 7.
All right. Can I have them? You can bring them down. Or there you go. Thank you, Deputy Krismer. You want to ask her apparently about the quality or status of your marriage. I don't know that this is refreshing her memory. I don't specifically recall exactly what she talked about, but it seems like you're suggesting that her testimony may have been that there were no happy or good times in your marriage, and you want to call her now and as some attempt to impeach her credibility, show her these photographs and introduce them through her. Is that your intent?
Not directly to impeach her, but to get a little more factual basis about our family life on the
Okay,
record.
to establish what, though? What's the end game?
To establish our, I suppose, Your Honor, that just that there was not these conditions leading up to this situation.
That there were times it appeared that you all were getting along fine at I don't know if that's Disney World or vacation, and obviously the two of you together, the family together, and that's your intent?
Yes.
Deputy Krismer? State, in an abundance of caution, I'm going to allow it as relevant. She'll be on the stand and be able to talk about it. You'll be able to cross-examine her on it, and just in an abundance of caution, I'm not going to make a finding that it can't have some potential relevance. I don't know what exactly his theory of defense is, so without that, I think that it would be dangerous for me to find that there may not be some relevance to it.
Yes, Your Honor. And so are you making a requirement that there needs to be some time frame that these photographs were taken, that they are made relevant, or they're going to come in?
Well, I think the time frame, I think she definitely has to testify to the time frame either on direct or on cross, and that'll go to the weight that the jury ultimately gives it and not the admissibility.
Yes, Your Honor.
All right.
Your Honor, I may I just show them rather than admit them for the jurors?
Well, the jury can't see them if you don't admit them into evidence.
Okay, then I will do that. I will ask them to be admitted. It is on my list of family.
Well, you'll still have to lay a foundation through her for them.
Yes.
But we'll see and cross that bridge when we come to it. As to relevance, which is the issue that I was sort of prejudging here, I think in an abundance of caution, I will say that they might be relevant. I just don't know without knowing his theory of defense, which I'm not requiring you to give me.
And then, Your Honor, the state had asked, I had 2 maps that are public information or just under the...
What do you intend to do with those maps?
I intended to ask Detective Steele if he could point out the routes traveled since he rode with the victim to make searches, and he was the lead detective on the case.
State, is there an objection to him asking that question on cross-examination? You intend to do that on cross or to call Steele?
On cross.
On cross of Steele, asking him about the routes and his investigation regarding routes?
I don't think I have a legal.
Yeah, and if he
basis.
uses those as either a demonstrative aid to assist the detective or to refresh the detective's memory.
I think a demonstrative aid would be appropriate, but not introducing it as an exhibit.
Okay.
Yes, as a demonstrative.
Okay. All right. I don't see any problems with that.
Okay,
All
thank
right.
you.
Are we ready for the jury? Let's get them. If they're ready.
They are.
All right.
All right, jury in your court.
All members of the jury are present and seated. Everyone else may be seated at this time. Gentlemen of the jury, welcome back. I do apologize for the length of the break. It was a little longer than we anticipated. I take full responsibility for that. Please do not hold that against the attorneys, the parties, or anyone else. Sometimes we are talking about legal issues in here, and at some point I do have to give my courtroom staff, including my court reporter, who is taking everything down, at least some break. So I do apologize for that, but as you know, we've taken your lunch orders. Our expectation is to do another shorter lunch to make up for any of that time, and the bailiff has taken your orders, and we'll do another 20 to 30 minute lunch and pick up where we left off. Again, thank you all very much for your patience and your service. Where were we? Cross-examination, I think? Mr. Summers, cross-examination of the current witness.
Morning, Mr. Becker.
Morning.
I wanted to go over a few things about you, about your process today. You had stated that the first property you went to was the Dubloom Road address.
That's correct.
And your supervisor was Corporal Blair?
He was the detective on scene.
Okay. And Corporal Blair, he walked with you through the photographing timeline?
Yes and no. Obviously, I kind of have an idea of what I'm there to do. He kind of relays a little bit of basic information, tells me anything that he knows about the case and what may potentially be important. But I go throughout the house photographing, everything as I see it.
Okay, so you have some decision-making authority over what gets photographed and what potentially is evidentiary value?
That's correct.
Okay. And Corporal Blair's testimony was that you first take photographs of the entire property, and then you start with marker 1, and that's when things can be more or less interfered with. Is that correct?
What do you mean interfered?
That nothing can be touched until marker 1 is photographed.
Well, nothing is really touched or disturbed other than placing the markers next to the evidence, but nothing is touched, nothing is moved until all those photographs are complete.
Okay, so nothing is touched until marker 1 begins. Is that correct?
Until everything is documented.
Until everything is documented. Okay. May I walk through those photographs with you?
Sure.
Your Honor, may I?
Absolutely.
Your Honor, I have set 1A1 through 104.
All right. And just like yesterday, just before you publish, just identify specifically which photograph you're publishing.
Yes, Your Honor. Publishing A2, set 1. Mr. Becker, this is the first photograph in the set that you took, the front of the home, correct?
That's correct.
Okay. And then I'm not going to show you every photograph, but then you did a perimeter of the outside of the home.
That's correct.
Is that correct? Okay. And nothing was touched at that point?
That's correct.
Correct. Okay. So in this photograph, A10 set 1, publishing A10 set 1, that is a screen leaning up against a wall?
That's correct.
Okay. Okay. Publishing A20, set 1. And this is what appears to be the first picture before you entered the home. Is that
That's correct.
Okay. And publishing A24, set 1. This is a kind of a broad photograph of the living room, correct?
That's correct.
Okay. And then the first bedroom that you come to is the one which is publishing A44, set 1. Is this one, is that correct?
I don't remember the layout of the house, but that is a bedroom.
If that's the first bedroom in your sequence, is that would be the first bedroom you took the photograph of?
I don't remember.
Do you know if these are in an order that you took them?
I have no idea.
Okay. You don't know that based on the timestamp or anything from these photographs what order you took them in?
If you have the metadata, I could tell you. Sure.
We do, but right now I'm just looking at the condition. This was the first photograph, according to our records, of the that bedroom. Correct?
Okay.
Well, let me ask you, just to clarify, is that the condition that you recall this bedroom being in when you first entered the home?
I do.
Okay. Okay. The photographs are continuing to go in an order, room by room, bathrooms, so forth. And then there's a large amount in the attic. Do you remember taking photographs in the attic?
I don't recall, but I'm sure I did. I was probably the only one taking photographs.
And publishing A67, set 1. This is another bedroom photograph. Is that the condition you remember it being in when you arrived?
I do.
Okay. And this is just another angle, publishing A68, set 1. It's just a little more view of that. Is that the same condition it was when you arrived?
That's correct.
Okay. And then publishing A73, set 1. This is a one other bedroom. Is this the same condition it was when you arrived?
As I remember.
Yes. Thank you. Publishing A76, set 1. Mr. Becker, what are those, looks like yardsticks?
Yeah, just getting a measurement of the height and width of the window.
Okay. And is that the first photograph that where those yardsticks or those measuring tools were used in this photograph series?
I believe so. I don't recall.
Do you recall if the measuring tools are used prior to the markers?
No, I don't recall.
You don't recall?
I don't.
Okay. Publishing A85 set 1. Mr. Becker, do you see the screen location and the screen position in that photograph?
I do.
Is it different than the first one I showed you?
It is.
Okay. Do you know how that screen moved?
I could have bumped into it while taking photographs. I don't recall.
Publishing A86 set 1. Mr. Becker, that's the living room couch. Do you recall the first picture I showed you of the living room?
I do.
And there were pillows all over that couch.
Mhm.
Do you know what's happened between the first time you took the photograph and this one?
Yes, it's searching. So as we're documenting the house, once the room is photographed as we see it, we can then begin to move items to look under things,
Okay.
to potentially look for other sources of evidence.
Okay. And does that compromise any integrity of the evidence that's there?
I don't believe so.
You don't believe so?
No.
And publishing A98 set 1. Mr. Becker, that is the same bedroom that I showed you a photograph of earlier.
Mhm.
Do you notice a substantial difference between the first photograph and this photograph?
Yes. So once a room has been photographed, we're now, the detectives or whoever else was there, they begin to search the room to uncover evidence, to look places that we haven't seen yet. So here we have a couple of markers placed on things that need to be documented. They weren't readily observed in the initial sequence of photographs.
Okay. Do you see how much clutter, I'll call it, is on that bed there?
Yeah.
Okay. Do you believe that has any impact on the sheet that was taken from that bed?
No, because the potential, the type of evidence that was discovered on the bed sheet would not have come from a piece of paper or any other piece of trash.
You couldn't have spilled out anything?
No.
It couldn't have...
It doesn't work that way.
Okay. I can only ask, sir. Thank you. Sorry, I'll keep that one at A98 set 1. I'll keep publish that again, A98 set 1. Mr. Becker, do you, in your investigation, attempt to see if any of the electronic devices are operable?
I did not.
You did not?
I did not.
Okay.
They were collected along with the power cords. We have a specialized unit within the sheriff's office that would look through any electronics, but I don't personally do that.
Have you ever done that?
No.
No. So you're not familiar with whether or not, if they're first reviewed by law enforcement for law enforcement to then determine?
Yeah,
If there's anything-
I just collect it.
Okay. I'll return these. And, I will continue with set P 1 through 50.
So item P.
Composite 1 through 50.
Yes.
You may proceed.
Before I go with these photographs, did you, the items that were collected from the home that day, you said there were a few items that you collected because of information that came from another detective?
That's correct.
And there was a large amount of items in all of those photographs. And I believe one of the items that you were told to collect as evidence was a water bottle.
I believe so, yes.
Okay. But there were no other cups collected during your investigation there?
Not at that time, no.
Okay. Do you recall? I'm sorry. You were also the one who photographed the second set of photos at that property?
Yes.
Okay. We'll get to them in a little
Well,
bit.
Second set, meaning,
On another day.
no, that was my only time was at that day.
Your only time was that day?
Yes, sir.
At Dublin?
Sir.
Okay. Publishing P11. Mr. Becker, do you see the items in the car there?
I do.
Which of them did you determine to be of any evidentiary value?
I don't recall. I'd have to look at my report to see if I collected the shoes from the front. I don't recall. But there were a few stains on the driver's seat. I don't know if you could see it in that photo.
A few stains on the driver's seat?
Yes.
Let me go to the next photo. We'll see if we'll see those. Publishing P12. I'm sorry. You said there are a few stains on that driver's seat?
There were. I don't know if it's in that photo. I think it may have been more on the back of the chair.
Okay. Let's look at the items just sitting on the floor. There is a hand sanitizer bottle or a soap bottle. Do you see that?
I do.
Do you think that would have been of any evidentiary value?
I have no idea.
Do you think a bottle like that could have had fingerprints taken from it?
Objection, Judge. Speculation.
Well, I'll caution the witness not to speculate, but if he knows based on his training and experience, he can answer the question.
Yes. Seeing how this is the victim's vehicle, we kind of knew who was involved at this point, so we limited our search to things that would precisely put those two people in the car. So we're not going to look at everything within the car in order to potentially gain a fingerprint or a possible DNA swab. We would be overdoing it at that point.
Okay. You said this is the victim's vehicle. At that point, had you made some kind of determination as to my guilt or innocence?
No.
Okay. So, in your professional opinion, could a soap or sanitizer bottle have prints lifted from it?
It could.
Okay. Moving to publishing P16. Mr. Becker, there's a few more items in the center console there. Looks like a McDonald's Frappuccino cup, a Dasani water bottle, and a pack of maybe dried cranberries. Do you see those three items?
I do.
And do you know if any three of those were collected?
Again, I'd have to look at my report.
Okay. If they were not, would any of those three items be able to have fingerprints lifted from them?
They could, yes.
Okay. Photograph P18, publishing. Mr. Becker, in this photograph, do you see a styrofoam platter with looks like a pancake or maybe something else on it?
Yes.
Okay. Could that styrofoam platter have been processed for fingerprints?
It could have.
Okay. Do you recall if that styrofoam platter was collected into evidence?
I don't believe so.
Publishing P19. Mr. Becker, do you see in this photograph a few more water bottles, a pack of cigarettes, and some trash in the door?
I do.
Do you believe that most of those items could also have been submitted for fingerprint analysis?
They could.
Thank you. Publishing P28. Mr. Becker, do you see on that back seat there on the floor, do you see a belt?
Yes.
Do you know if that was collected into evidence?
I don't recall.
Do you, at this point, know what some of the allegations are in this case?
No.
Do you know it was a kidnapping?
No.
How would you then say that this is a victim?
Well, we have a person who's been removed. It's not up to me to say if they're kidnapped or not. It's not my line of work.
So if you don't know any of the initial allegations against the defendant, how do you determine what to collect and what not to collect?
We just make our best guess.
Okay. So if some things were missed, that would not have been, that would have been just an error?
Yeah, it's an imperfect science. We do the best we can with what information we have.
Okay. Also in that photograph is a white tote bag. Do you recall seeing that in the vehicle when you
I
photographed
do.
it?
Mhm.
And could either the belt or the white tote bag have either some value as to prints or DNA evidence?
It could.
Okay, thank you. Okay. Publishing P30. Mr. Becker, that is the white tote bag open, correct?
That is correct.
That's your hand holding it open?
That's correct.
And did you happen to take any of those items out and photograph them?
I don't believe so.
No. Do you believe anything in there could could provide fingerprint or DNA analysis?
Yes, I do.
And do you remember why you didn't check anything in that bag?
I think we knew who it belonged to.
Okay. But does that need much?
Objection, judge, speculation.
I'll sustain. Let's move on.
Publishing P31. All right, Mr. Becker, there are a large number of items in this back seat. Do you see a variety of color binders or folders?
I think that's what that is, yes.
Okay. And do you see a pack of, it looks like baby wipes?
Mm-hmm.
Do you see, I'm sorry, not yet in that photograph. Do you believe that the baby wipes package or the other items that were not collected have any potential DNA or fingerprint analysis opportunity?
They could.
They could. And publishing P32. Mr. Becker, there's a McDonald's cup and maybe a coffee mug sitting there in the third row in a cup holder. Did you happen to inspect the contents of either one of those?
I did not.
You did not. And was there any reason you decided not to check either of those two items?
Never having seen this vehicle before, it looked a little bit messy. It is not unlike my normal routine to find trash in people's cars, so I don't go about inspecting every piece of trash.
Okay. Do you recall what kind of substance may have been in that McDonald's cup?
Could have been iced tea. I don't know.
That's probably correct. Thank you, sir. Publishing P36. Mr. Becker, do you see the pink, kind of shiny book sitting there?
Yes.
Did you happen to read through it or look through it at all and take photographs of the contents?
I believe it was collected. I don't remember going through it, though.
Okay. Is it typical that if you collect a book or a package of papers that you would photograph every page?
Not typical, no.
Not typical? Okay, thank you. Okay, and publishing P39. Mr. Becker, there's a suitcase there, correct?
That's correct.
And do you see the pile of clothing on the right of that suitcase?
I do.
Was that pile of clothing put into evidence?
I believe a few items of it were.
A few items of it?
Yes.
Do you recall if your report just says clothing from trunk?
It may.
Okay. And if it says clothing from trunk, should all of that clothing be in evidence?
It should.
Okay. And if anything was missing from that evidence, would it that would be a mistake?
If anything, I'm not following your question.
You said if your statement says clothing from trunk, and clearly that is the clothing from trunk, but not all of that clothing would be in the evidence, would that be a mistake?
If it was, you mean outside of the suitcase?
Yes.
Yeah, outside of the suitcase. If it was clothing that came from the trunk, it should be.
It should all be there.
That's correct.
Okay.
There was one piece that was separated, which was the green sweater.
Yes. Okay. And did you feel that all of that clothing was important?
No, I think I remember it being wet, so I think that's why it was treated differently.
Okay. And was it muddy?
I don't recall mud.
You don't recall?
It's possible.
Okay. Publishing P40. And Mr. Becker, do you see the contents of that? What appears to be inside the suitcase?
Yes.
And did you go through the contents of this suitcase?
I'm sure I did. I don't recall.
Is there a reason why this is the only photograph of the inside of that suitcase?
Yeah, I don't know how many photographs you have, if you have all of what I took or not. So.
We do.
Question, Judge, he does not. There are multiple photographs the state collected. The state chose certain photographs to introduce.
All right, let's move on.
Okay. Did you feel it was unimportant to put any of this clothing into evidence?
So I don't really make every determination about what goes and what gets submitted into evidence or not. I'm working with, at this particular time, Detective Garcia.
Okay.
He has a lot more information about the case than I do. So my role in this is really just to document and collect what he thinks and collect what I think may be relevant.
Okay. Thank you. Mm-hmm. Do you recall if any of that property was put into evidence?
I don't think anything from the suitcase was placed into evidence.
Okay. And publishing P46. Mr. Becker, do you see a pack of documents there on the carpet?
I do.
And did you happen to go through any of those documents?
I may have. I don't recall.
Okay. But if you had done that, you didn't find anything of potentially evidentiary value?
I just don't recall. Yeah.
Okay. Thank you. I'll return these photographs. Your Honor, I'm using exhibits V as in Victor, 1 through 10.
Thank you.
Mr. Becker, I'd just like to talk to you about the last set of photographs that you took in the hospital.
Okay.
Do you recall what time you took the photographs?
It's probably a little bit after 6 o'clock in the evening.
6 o'clock in the evening?
After that, 6:05, 6:10 approximately.
Publishing V2. Mr. Becker, so that is the condition that you found me in at 6 o'clock in the evening?
That's correct.
Publishing V3. Mr. Becker, when I arrived, was I awake or sedated?
I can't speak to
Sleeping, sorry.
Yeah, I don't know. I'm not a medical professional.
Was I awake?
I don't know.
You don't know?
I don't know.
Okay. And from that photograph, the last photograph, you saw that there was a bandage on my neck,
That's correct.
and that was placed there by medical staff.
That's correct.
Publishing photo V6. Tell me what you see in that photograph, Mr. Becker.
That's me removing the bandage.
It's you removing the bandage.
Yes.
Okay. You didn't ask for anyone from the hospital to assist you?
I asked if I had permission to do that, and they said sure. So there's just a couple pieces of flimsy tape.
Okay.
Yeah.
Publishing photo V8. Mr. Becker, those are what look to be a pair of boxer shorts.
Mm-hmm.
Do you know if those were collected and put into evidence?
They were.
Okay. That's all of these pictures. I'll return them to the clerk. Thank you. And Mr. Becker, at the hospital, were you accompanied by anyone?
I believe there were deputies present, but I don't recall if there was a detective there or not.
Okay. And at the second set of photographs, which was the cop photographs of the vehicle, do you recall who was who was helping you with that?
That would have been Detective Moises Garcia, and I believe my squad partner was there, maybe just to hold a bag or something like that if I was to collect something from that vehicle.
Okay. And Moises Garcia then would have been the other detective who also made some decisions about what to and what not to collect?
That's correct.
Okay. No further questions, Ryan.
All right. Thank you. Redirect.
Yes, Judge. Mr. Becker, prior to documenting a scene, are you given a brief summary of what is known about the facts of the case or an investigation at that point?
Yes, and oftentimes it's very brief.
So I assume, is it safe to say that the information that you knew on the 12th when you were photographing and documenting the scene at Dubloom was much less information than you had of the photographs at the time you took the photographs on the 13th?
It was.
So let's talk about the vehicle for a little bit. When you documented the photographs of the vehicle, were you aware of the individuals, the victim and the defendant, had been located in that vehicle?
That's correct.
So if they had been located in that vehicle, would you anticipate on finding their prints in that vehicle?
Absolutely.
So if a print was found, say, on a hand sanitizer bottle, fair to say it's not going to say whether or not it would prove they were in the vehicle?
That's correct.
Okay. Are you aware of anything else that would prove other than that?
No.
Okay. Let's talk about the letters, though. At the time when you were documenting the scene of that vehicle and you took photographs of those letters, you collected those letters, did you know who wrote those letters at that time?
I did not.
So did you decide to determine if there were prints on those letters to determine if the person who wrote those letters left their prints behind?
That's the reason.
Okay. On the Is it fair to say that you, of the home of the doubloon, you took a couple hundred photographs?
Yeah, that's probably accurate.
And of the victim's vehicle, you took 70 photographs?
Sounds accurate.
Do photographs sometimes overlap, or are they duplicative in nature?
Oh, absolutely.
Okay. Nothing further, Judge.
May this witness be released by the state
He's released, Judge.
and released by the defense?
Yes, sir.
Thank you, sir. You may step down. You may be released as a witness at this time. You're welcome. I will ask the state to please call your next witness.
Ricky Navarro.
Navarro.